Out front now, Evan back with me, along with CNN's legal analyst Carrie Cordero and John Dean, former Nixon White House counsel. John, if we could begin with you, Evan's exclusive reporting tonight on the Justice Department investigation. What does it tell you that federal investigators are going to such lengths to prepare for battle over these executive privilege claims for former Trump White House officials? Is that about those former officials, those around Trump, or could it be about Trump himself?
I think it's a legal issue, and it's being used as a device to suppress testimony. Trump is calling on a very thin and unlitigated area of executive privilege. Big picture, there is no privilege. Biden has said he's not invoking executive privilege. The Presidential Records Act, which was adopted in 1978, says it is the president's call. He is the incumbent. He is the one who has authority over executive privilege. But there is an opinion from the year before, 1977, that says prior presidents can invoke executive privilege. But there are no documents involved in this. And this is their exchanges between themselves and Trump. And he's claiming executive privilege over that. That's not litigated. They don't want to have to litigate that. That would go to the district court, the Court of Appeals, to the Supreme Court. And with a 6-3, with the 6 being very unpredictable since they don't always follow the law, this is kind of a troublesome area. This is what they're gearing up for, it appears to me, and are getting ready to mount a fight if necessary.
Carrie, you've often wisely injected some caution as to what we know and what we don't know about how far this investigation might go. Based on these latest moves, who do you see as the target of these DOJ steps here? I mean, is it folks in Trump's circle, as I was asking John, or is it Trump himself potentially?
Well, I think it's definitely folks in his circle, including potentially his former chief of staff, people who were very close to him in the White House. I think this most recent information really demonstrates as a practical matter that some of the witnesses, including the former Pence advisors, have more to say. So there clearly is some information that they could have provided to the grand jury and did not. And potentially are relying on executive privilege, even though the current president is not invoking it. And so then the Justice Department is working through how they can get more of that evidence. And so the testimony before the grand jury, the ability to get information from witnesses pursuant to a lawful subpoena, is how the Justice Department determines whether or not they have potential charges against individuals, whether those are folks close to the president or potentially the former president himself. But it's an investigative step, and it indicates that the Justice Department is really thinking through ahead of time how they can do this, because traditionally the Justice Department would be arguing to protect presidential prerogatives.
Evan, you can learn a lot based on the questions that prosecutors ask the witnesses, and you're learning more about those questions. What do you know, and what does it tell us?
Well, Jim, we know that these two witnesses in particular, Jacob and Short, were asked directly about the pressure campaign, and they answered those questions. They spent hours talking to the grand jury about those meetings, especially the one on January 4th, where we know the former president and John Eastman were pressuring Pence to say that he had the power to set aside the election results. What I'm told is that they were able to answer a lot of those questions around the edges, provided a lot of information. So even though they could not reach the exact discussions between the former president and Vice President Pence, for instance, or between Mark Short and Greg Jacob and the former president, there is a lot of information they were able to provide to the grand jury. And so what we can expect, as Carrie is pointing out, is that this is a beginning, and we expect that they're going to come back. They're going to be able to come back to them and try to, get through the presidential privilege issue to try to get additional information from those witnesses.
John, we did learn today that the January 6th committee spoke with former Treasury Secretary Steve Mnuchin, so separate from the DOJ investigation here. And among the things they asked about were about this effort, as reported by John Karl, to invoke the 25th Amendment by Trump's own cabinet officials in the wake of January 6th. Why do you believe the January 6th committee would focus in on that? I mean, does it get to state of mind as to what they thought the president was up to and was capable of then?
I think it certainly shows the feeling of those around the president about his state of mind. It's not a good process to invoke the Constitution to place him on a disabled list. It's really very awkward. I happened to work on that amendment when I was with the House Judiciary Committee, and the vice president has to send a letter to the speaker and the president pro tem of the Senate, telling him that the president is incapable of carrying out his responsibilities under the Constitution. The president, all he has to do to neuter that is send a letter saying, I'm perfectly capable. These are people who are just trying to get me out of the way. They don't like my decisions. And to put that in play, then the vice president has to send another letter back to the Congress and say, no, he really is in bad shape. Then the Congress has 4 days to resolve it. I think that it's pretty likely they would have resolved it in favor of Trump in this instance, even if they didn't like his policy, because this amendment to the Constitution wasn't designed for this kind of activity.
It's a good point because it's not exactly a swift or easy process. Kerry, you think the committee could actually hurt its case by going down the path of investigating the 25th? Tell us why.
So I think the committees, if they were to argue, what's their interest in doing it, it's to create a historical record of what actually transpired surrounding the events around January 6th. So from the historical perspective, I understand why they might be interested in it. I don't think it's a really great use of their time if what they are really trying to do, which they have communicated both in their hearings and in many of their other statements as these hearings have taken place, is that they are trying to demonstrate that there is a potential criminal case to be made against the former president, which is it's something that they are trying to produce evidence that then is relevant to a Justice Department investigation. And in that perspective, I think arguing or exploring in more detail the arguments that the former president was lacking in mental capacity actually is counter to a potential effort to demonstrate that he had intent and that he actually was of sound mind and was purposefully trying to overturn the election. So I think they potentially need to think through how they might be working at cross purposes there.
It's a good point because we've often talked about intent and how central that is to the criminal side of the investigation. Evan, Kerry, John, thanks to all of you.